most successful. I mean, if you just think about it, if you're trying to replace a system where the people vote with a system where a group of experts advise the governor and the governor makes an appointment, it's not hard to get out there and run a couple of TV ads and say, these elitists want to take away your right to vote. And that's how this has played out over the past several decades whenever someone has tried to get rid of a system of elections in a given state. So they're probably here to stay, and that, I think, means that the question that folks that care about the judiciary should ask is not what's the best system if we were designing this from the ground up, but how do we improve the systems that we have? And improvement is certainly necessary. Some of the most egregious cases, as I said, come from states with judicial elections, and I want to just give a couple of very quick examples. These are obviously not from New Jersey, but they give a flavor of what's going on in the rest of the country and why there is so much widespread public perception that the judiciary is really broken at this point in some ways. The first example I'll talk about is from Wisconsin. I was actually in Wisconsin last week, and we had a panel discussion talking about some judicial independence issues, and it was ironic because the day it was scheduled ended up coinciding with the day that a panel of the Wisconsin Supreme Court heard a petition to discipline the newest member of the Supreme Court. In Wisconsin, they actually have nonpartisan elections, but they have contested elections to choose Supreme Court justices. And last year, the most recent race for a seat on the Wisconsin Supreme Court involved the newest member, whose name is Justice Gableman, who was running against a sitting member of the court named Louis Butler. And without getting into the full story and all the back and forth, suffice it to say it was a vicious campaign. It involved a lot of mudslinging, a lot of really scurrilous attacks, and really misleading attacks, certainly. And the result, in addition to Justice Gableman taking the bench, is that Justice Gableman, as soon as he got to the court, was faced with a potential censure for lying in some of his campaign commercials. He accused Judge Butler of coddling criminals, being soft on crime, working to find every loophole to put criminals out on the street, and in fact went back several decades ago to some cases that Butler had when he was a public defender, which he was as a young lawyer, and suggested that some of the criminals that he had represented back then had been folks who came before him when he was a Supreme Court justice, and he worked to set them free. Well, Justice Gableman is now facing potential removal from the court because of some of the lies in his commercials, and he may not be removed. I doubt he will, but I think he may realistically be looking at a censure for the misleading advertising. But whatever happens to him, I think, is not really important to the larger point, which is that this is very typical. We've seen an arms race of money flowing into judicial elections. We've seen judicial elections increasingly looking exactly the same as any other political races. And I would submit that that's not healthy for the judiciary and for the democracy. When the courts, which have such a unique role, begin to look just like the Congress and the other places where the political sausage gets made, I don't think that's healthy for the court system. The second case that I want to discuss, at least briefly, illustrates many of the same issues. This is a case that came out of West Virginia, and some of you may have heard about it over in the early part of the summer because the Supreme Court decided the case, I believe it was June 8th. At any rate, at the beginning of the summer, the United States Supreme Court weighed in on this case. The name of the case is Caperton v. A.T. Massey Coal Company. And this is a case that stemmed out of a dispute between two coal companies in West Virginia. And ultimately, the Supreme Court said that a judge violates the due process clause of the United States Constitution if the judge sits and hears a case involving one of the parties in the case who has spent egregious, extraordinary amounts of money putting that judge on the bench. To put it simply, if one of your biggest and most influential campaign supporters, who is largely responsible for you winning your seat on the bench, shows up in your courtroom, step aside. Let another judge, who's not got any chance that they might be biased, hear that case. I could talk about this case all night. We, at the Brennan Center, were very involved in some of the efforts to bring amicus briefs or friend of the court briefs in from various groups. It was really a remarkable effort in that in addition to sort of traditional good government groups like the Brennan Center and other folks that you'd expect to be weighing in, we had folks that you might not always think sit in the same ideological box as we do. Walmart, Pepsi, Intel, Lockheed Martin. A number of these corporations came in and took the exact same position that some of these sort of liberal, progressive type of groups took. Because basically it's a fundamental value that judges shouldn't be biased. And the companies don't want to feel like they have to pay to play. The companies don't want anymore to have these arms race spending in judicial elections, so they feel like, my God, we can't not pay these judges. We can't not try and buy these judges. The competition's going to be giving them money. If we want to have a fair shake, we better pay too. So really a wide range of different voices was involved in weighing in this case. Just a thumbnail sketch of the case. In 2002, there was a $50 million judgment that was entered against Massey Coal Company, the defendant in the case. While that case, over a couple of years, worked its way through the judicial system up on appeal, the CEO of Massey, the company that was hit with the $50 million verdict, the CEO decided he didn't like one of the judges on the Supreme Court because that judge was hostile and had ruled against interests like Massey's in the past. So he decided he'd spend about $3 million to make sure that judge lost and to get his favorite judge, a guy who was very friendly to business interests, on the bench, Justice Brent Benjamin. That $3 million was more than every other contributor to the campaign combined. It was 60% of all the money spent on behalf of Justice Benjamin, and it was money well, evidently, because he won. He took the bench, and right after he took the bench, the appeal got to the Supreme Court in West Virginia. Caperton, the plaintiff in the case, the party that had gotten the $50 million verdict, asked Justice Benjamin to recuse himself and step aside since there were legitimate questions about whether he could be fair and impartial. Justice Benjamin consulted with himself and decided he could be fair. So he told them he didn't need to step aside. He was perfectly qualified and fair. And then he cast the deciding vote. He tipped the balance and cast the third vote in a 3-2 decision to throw out the $15 million verdict. Caperton, perhaps unsurprisingly, was not pleased with the result. Took the case to the Supreme Court and said, you know, it's a simple concept. When somebody has spent the lion's share of all the money for the campaign for the judge, and reasonable minds could certainly think that that judge might be biased, due process is violated if the judge doesn't step aside. Now, the due process clause, of course, is a